My name is Joy, and I have a CPS case, and Mr. Davis is my lawyer. I found him in the internet when I was searching because when my son got taken away by CPS, and every time I go to Mr. Davis, it always make me feel better when I go home. He helped me a lot. Before I only have 2 hours visitation. Now they give me 3 times a week and 2 hours.
Good morning. Welcome to CPS Office Hours. I'm Attorney Vince Davis, and today we're going deep into a powerful, eye-opening topic. CPS secrets, what social workers don't want you to know. This is going to be 30 minutes of a truth serum for anyone caught in the CPS system. If you want your kids back, if you want to know how the system really works, this is for you. And if this helps, I invite you to hire me for a consultation. Let's turn your knowledge into results. Let's get started. Secret number 1, the case is built before you ever get to court. Most of the damage in a CPS case is done in the first 48 to 72 hours before your first hearing. Social workers pre-write the narrative in something called a detention report, and they prepare the allegations against you in the juvenile petition. All of this is prepared before you have your first court date. Judges heavily rely on the evidence presented to them by CPS. If you don't counter this evidence, the CPS narrative goes unchallenged. What to do? Well, the solution is to immediately begin collecting documentation, creating a timeline, and submitting formal declarations and exhibits through your experienced CPS attorney. This is key. If you don't show up to the first hearing or any hearing with your own evidence, be it witnesses, be it documents, the judge only has the evidence from the social worker. All you and your attorney can do is argue. And as we know, and as I've said many times on this show, attorney argument is not evidence, and judges make decisions on evidence. All right, secret number 2. Voluntary safety plans can be legal traps. Not truly voluntary, they're opened or coerced, often used to avoid court and due process. Used later as evidence that you might have admitted guilt. What you should do: never sign a voluntary services agreement without legal advice. Always seek and always ask, will this be used in court? Secret 3. Judges only have CPS's version of events unless you correct it. Judges depend on what is filed in the court record by the social worker. This is a matter of law, that they must consider the social worker's reports. If you don't formally submit rebuttals, the judge has no choice but to rely on the social worker's reports. So this is what you should consider doing. File written declarations correcting the record. Submit exhibits and third-party documentation to help prove that the social worker is wrong or help to prove and explain your position. Make sure your attorney speaks clearly on the record and makes the arguments. I get a lot of calls where people tell me, Mr. Davis, I went to that first hearing or I went to any hearing and my attorney didn't say anything and we lost. Well, if your attorney doesn't say anything or present any evidence, you're going to lose. Your voice must appear on paper in evidence. Secret 4. Your court-appointed attorney may be overworked and underpaid. Many court-appointed attorneys handle 100+ cases at a time. Decades ago, when I was a court-appointed attorney, I averaged about 350 to 400 cases a caseload. As a matter of fact, many years ago, there was a federal lawsuit against a county or a state where the person sued and said that his attorney couldn't properly represent, I think in that case, the child, because the attorney had too many cases. And surprisingly, the U.S. District Court, in a three-panel judge decision, said, yeah, the court-appointed attorney had too many cases to represent the child or children on his caseload. And they went through a lot of expert testimony about the number of cases an attorney could handle at any one time. And they used a lot of testimony from experts and people who have, practiced in the system. And I think, and it's just my recollection, I think that that court in that county, and I think it was Mississippi or Georgia, decided that the attorney can only have like 62 or 67 cases at one time. Well, I challenge you, ask your attorney how many cases they have and that they handle at any one time by themselves. A lot of court-appointed attorneys don't file motions, challenge evidence, or object. Key phrase, object to evidence presented by the social worker. Parents wrongly assume that they'll take care of it. They also wrongly assume that they're entitled to Johnny Cochran. Neither is true. As a matter of fact, there's a appellate court decision on the qualifications that you are entitled to in a court-appointed attorney. And it's not what you think. Again, you're not entitled to Johnny Cochran. What to do? Well, you should consider hiring your own attorney if possible, or learn how to work with and prod your attorney, your court-appointed attorney, into making filings, answering your questions, and preparing for a hearing before the juvenile court. All right, let's take a quick break. We've covered 4 massive CPS secrets. Drop your questions in the chat. And if you're in a fight right now, book a private consultation with me. I've handled thousands of cases during my almost 40-year career. You can call the number right on the screen, bottom right, 888-888-6582, and book that consultation. Don't wait. I get so many calls from people that tell me, told me Friday, Mr. Davis, on Monday, they're having a hearing to terminate my parental rights. I've been watching your videos for years, months, weeks, but you call me the business day before they're going to terminate your parental rights, and you think that I can do something? I'm a lawyer, not a magician. Call me with sufficient time to counsel you, to investigate, to review your case. Do not wait to the last minute. All right. Secret number 5. Visitation is a setup or a show of strength. Every visit is observed and documented. Your tone, mood, language, body language are all recorded and written down. CPS is looking for proof that you're unstable and disengaged in your visit with your child. What do? You treat every visit like a courtroom exhibit. Bring structure, warmth, and parenting power. I've made videos on the topic of what to do during these successful visits, so check that out on my YouTube channel. Secret 6. CPS social workers have quotas and internal pressures. You ever heard that story or that rumor that police officers are required to write a quota of traffic tickets? What makes you think that quota and that type of pressure isn't applied to CPS workers? There's pressure to move cases and meeting federal and state mandatory guidelines and timelines you know nothing about. There are incentives which exist for adoptions and permanency outcomes where your child is not returned to you, not placed with you. These influences how hard they fight against reunification is, placing the emphasis on a case in the wrong place. Governor, when it was Governor Arnold Schwarzenegger was governor of California, he engaged the Hoover Commission to investigate CPS. In their final report, they said something like the financial incentives in the CPS system are wrongly placed. The financial incentives were based upon keeping children away from the home and not reuniting children with their parents. Secret 7, your case plan is a test, not a path. The services aren't really meant to help you. They're tests. The plan is vague on purpose to control and trip you up. If you miss one thing, it's non-compliance and your children aren't returned. What should you do? Complete everything early. Ask for written confirmations. Keep records of every effort. I've done YouTube videos on what you should do during your family reunification process. Please check those out. All right, secret number 8. CPS often ignores relatives, even when the law favors them. You have a legal right to request your children be placed with family or friends of the family. CPS sometimes stalls, delays, or avoids this because whenever your child is placed with family or a friendly relative, the case shifts. It's like, if you were arrested for a crime and you were put in jail, if you get bailed out, it's easier to defend the case. The same way with children in foster care. If they're placed with friendly relatives and friendly family members or friends of the family, it's like being bailed out. It's easier for you to defend the case. So CPS inherently doesn't want the child to be, returned. When a child is in foster care, and I learned this maybe a couple of years ago with definite facts, foster parents are professionals. In other words, they get their business from social workers. And it is my firm belief that social workers implicitly or explicitly confer with the foster parent to get children to have certain attitudes or say certain things against the parents. Hard to imagine, isn't it? You thought this was all fair. What to do? File for a formal relative placement request. Ask your attorney to press it with the court at each court hearing, at every court hearing, and to do it now, not wait. Secret 9. The child's attorney can make or break you. Children's attorneys are like everything else in the world. There are great ones, and then there are terrible ones, and then there are a lot in between. Some do their jobs. Some side with CPS automatically without further investigation because it's a safe play. They don't always speak to the child, and judges trust their word maybe more than yours. What should you do? Document your child's real interests. Ask for a change of counsel if appropriate. Provide letters from therapists or teachers. Now, you probably cannot talk to your child about where they want to be placed or their wishes because you will be accused of trying to unduly influence the child slash witness. But you can find out the wishes through the counselors, through the therapists, even having your attorney speak to the minor's attorney about what's going on with the child. Secret number 10. CPS files are often inaccurate or fabricated. Reports may include exaggerations, outdated info, or outright errors. And if they are not challenged, they become the court's truth. What you should do: demand discovery. Compare claims to actual evidence. Ask your attorney to file objections or corrections. You know, one of the things that social workers maintain as an almost daily diary of your case is something called the delivered service logs. Now, I believe that this is the same in every state because delivered service logs are mandated daily diaries and reports that are mandated by the federal government, by the Department of Health and Human Services. And this is what happens on your case. Anytime the social worker wants to diary what's happening on your case, and they're supposed to document everything. In California, they open up a computer system called CMS CWS, and they type in by date and time. Those logs are saved by the county and the social worker. And I think social workers know this, and I've come across a few situations where social workers don't know this. Those logs are transmitted automatically to Washington, D.C., to the Department of Health and Human Services, who maintains records on every case. And in civil rights cases, I've discovered in some cases that the daily logs are gone back and they're altered. But you can always get the original input into the case by subpoenaing records from the Department of Health and Human Services. A time-consuming task, but something you may want to talk about and look into for your CPS case, as well as if you have a civil rights case against against CPS. Secret number 11. Most parents don't know they can appeal. So whenever a judge makes a decision in your case, you can appeal it to a higher court and then even to the state Supreme Court. And theoretically, you can appeal it to the United States Supreme Court. Now, I said after every decision or order the judge makes that you don't like, you can quote unquote appeal. Now, in California, that's a term of art. Appeals are divided into two categories. Number one, true appeal is where the Court of Appeals has to make a written decision. All right. There are other types of discretionary appeals where the Court of Appeals can decide whether they want to make a decision, and those are called writs, WRITS. In California, if your family unification services are terminated, you can appeal, but they call it a special writ, WRIT. And there's a whole lot of reasoning for that. I won't get into that today, but suffice it to say, you can appeal or writ any decision. In California, automatic appeals can be filed where there is a disposition hearing, a 6-month review hearing, or the termination of your parental rights. So you want to talk to your attorney about what's appropriate, appeal or writ or special writ, and make sure that he or her helps you in that process. And remember, for appeals and writs, the deadlines are very short. Few people or few parents fully understand this. I had a person contact me recently that wanted to file an appeal based upon a judge's decision from 2 years ago. I was sad to say that I had to tell that parent, you had 60 days. You've waited 2 years. You can't go back. If you're going to appeal, do it now and do it soon. Remember, ask about appeals and writs immediately after any ruling against you. Don't miss guidelines. And, you may want to ask your attorney face to face. There's nothing like memorializing that in a follow up email to your attorney. Secret number 12, you can sue CPS in the right circumstances. If CPS removed your child without a warrant and without emergency circumstances, call it exigent circumstances, you can sue your social worker and the county or state. You can sue them if they violated your civil rights. For example, they fabricated evidence. They coerced confessions that weren't true from the child. They lied in social worker reports filed with the court. Always talk to an experienced CPS civil rights attorney about your rights and what you can do. And let me tell you right from the beginning, it is unlikely that suing the social worker for civil rights violations will force the social worker to return the child to you. When you sue social workers for civil rights violations, you mainly go after monetary damages. You can go after injunctive relief to make a social worker do something or stop a social worker from doing something. Those cases are hard to prove and hard to win. But again, consult with a civil rights attorney that sues social workers. Remember to gather records, timelines, witnesses, then consult with that civil rights attorney, like me, about a 42 USC 1983 civil rights lawsuit filed in the U.S. federal courts. We just spent about 20 minutes covering 12 CPS secrets that can make or break your case. These are real. This is very serious. This is why you need a strategy, not just a hope. Talk to me or talk to an attorney about a consultation. Let's take your case apart and rebuild it for victory. Consider joining my Fight CPS School, skool.com, for weekly support, downloadable motions, and survival tools. I'm attorney Vince Davis. Stay powerful, stay informed, and I'll see you tomorrow during my CPS office hours on the front lines. I also want to tell you later today, whatever platform you're watching on, please return to it. You'll find a free handout about today's meetings and the 12 CPS secrets that you'll be able to download for free. Before I sign off, let me look at some of the questions that have been posted this morning. Okay, you will never know on YouTube says, my ex-caseworker got fired for falsifying information on other cases and charged with sex traffic of minors. DSS refused to tell me all of her charges and banned me from the DSS office. What can I do? Well, you will never know. This is what you should do. You should call me, 888-888-6582, and let's get into it. This happens more often than you might realize, where social workers may have lied, quote unquote, exaggerated your case. You have a right to know. Okay, Neri Galindo on Facebook says, "Good morning, Mr. Davis. My name is Neri Galindo. Did you get a text message I sent you? God bless you and your team. You're a badass. Cinco de Mayo. Is today Cinco de Mayo? Oh, tomorrow is. Tomorrow is. Okay. Neri, I don't know if I got a text from you, but try to send it again, and I'll try to respond to it sometime this morning. After after the show today, I'm supposed to be going on a walk, doing a little workout, so I won't be looking at my text really until later this morning after the walk and breakfast. Then we have, I can't pronounce it, Dotrick, Cruel.Rick, Cruella.Rick, Cruella.Rick watching on YouTube. Other than 42 USC, are there any more applicable citations for civil rights defense? I mean, if you mean civil rights, bringing a civil rights case against the social worker, yes, there are. There's the 14th Amendment, which is covered usually by 42 USC 1983. And there are related statutes before and after 1983 that talk about different types of damages, punitive damages you can get, attorney's fees, stuff like that. There are state claims. 42 USC is a federal claim. There are state claims that you can bring, state constitutional claims you can bring. What I would do, Cruella, is I would talk to a civil rights attorney. Trying to bring a civil rights case against a social worker or a governmental agent is not something you should try at home. Okay, it's much more complex than you might ever think. I recently had a guy that he's not a client, but I talked to him. Excuse me, and we text often. I never represented him formally in the CPS case, which he lost, and I don't represent him in the civil rights case. And he filed a civil rights case, and now it's on the verge of being thrown out, dismissed, because he doesn't know all the procedural and evidentiary rules. You know, he just felt that, hey, I was done wrong. And from what he tells me, he was, put through the mill and he was done wrong. But he's going to need, someone to help him. And unfortunately, he's been a very successful person in his life, businessman, and he thought he could do the civil rights lawsuit himself, despite me trying to nicely tell him, I don't think you can do this. So he's on the verge of getting his case or having his case dismissed. Cruella Dotrick says, I lost my appeal in the Court of Appeals. Okay. Remediator was filed earlier this year. Where do I appeal now? Or can I? Cruella, you could have appealed to the state Supreme Court, but you have probably waited too late to do that. Remember, in the talk that I just gave, the 12 secrets, there are important deadlines in the appellate process. You just can't wait around and think about it. You got to move fast. So, Cruella, if you call me, we can discuss it. But it sounds like you might have waited too late because we're already in May, and you said your remediator was filed earlier this year. So give me a call. We can chat about it. Margaret King, one of my favorites, a member of my YouTube channel. She says from YouTube, good morning, Mr. Davis. What can a guardian/parent do to prepare for a JV 183 hearing? And should the parent show up to the CFT meeting? All right. Margaret, first of all, let me ask the first question. To prepare for the JV hearing, it depends on what your JV is requesting. It will depend on how to prepare. Mainly, you want to gather all of your evidence, talk to your attorney, which is me, about how to introduce that into court. We want to make sure that the evidence gets admitted. And should a parent show up for a CFT meeting? That's a hard question to answer. My general rule is no, but I have 1,000 exceptions. So if you want to discuss those with me, give me a call. And Margaret, I know I owe you a dinner. We were supposed to have dinner via Zoom on Friday night. An emergency came up. So text me or call my office and set up our dinner meeting on Zoom. Cruella Dotrick, thank you. You're welcome, Cruella. Cruella also says, I understand. Thank you very much. Great. Okay, Betty Jo Wilderhold on Facebook says, what happens when the child's GAL asks for discovery requests? Well, when anyone asks for discovery requests, each person that they ask of has to respond and give information. So if you have those quote unquote secret witnesses that you plan on springing on CPS at the trial and at the on the judge, and they ask for discovery, you better give them the information, because if you don't, that information could be excluded at the time of trial if not disclosed earlier. That's a pretty hard and fast rule here in California. Cruella Dotrick on YouTube says, I would appreciate a call. I was aware of the deadline. I just wasn't able to curate the petition for review on my own. My resources have been extremely limited. Cruella, I don't have your number, so you're going to have to call me. 888-888-6582. Okay, Margaret, smiley face. Margaret on YouTube. Okay, thank you so much. Have a wonderful day. Thank you, Margaret, for being a member of my YouTube channel. All right, Betty Jo from YouTube says, what happens when the child's GLL? Okay, I just answered that. Okay, Cruella Dotrick again. I planned to file for an extension due to an unexpected lengthy delay for the court transcripts to make their way to me. I've requested for months on end, and neither via email or snail mail. Okay, that might be a basis, Cruella, to get an extension and file a late petition to, if you're in California, to the California Supreme Court. We'll have to talk about it. But filing it without asking for an extension, it will just be denied. All right. We've come to the end of the show, a little over there, and no more questions. So I want to thank everybody for watching. Don't forget to return to the site that you're watching the show on later today, because you should be able to get the handout and checklist that I've prepared based upon today's presentation. And everyone have a good Sunday. Stay safe. And we'll see you tomorrow at 6:30 a.m. Pacific Standard Time for office hours. Bye-bye.
My name is Joy, and I have a CPS case, and Mr. Davis is my lawyer. I found him in the internet when I was searching, because when my son got taken away by CPS, and every time I go to Mr. Davis, it always make me feel better when I go home. He helped me a lot. Before, I only have 2 hours visitation. Now they give me 3 times a week and 2 hours.